Okay. So, before the break, we looked at the two-stage approach that has been put forward by Lord Millet in Agnew, which indicates a slightly different approach to looking at parties' intention as expressed in documents to the one that you've been studying so far. So normally we look at contracts and we cherish freedom of contract, we cherish the intention that parties have expressed in the agreement, and we think that English courts are, in their approach, quite benign in interpreting parties' intention and construing parties' intention on the basis of the agreement. But what Lord Millet suggests is perhaps beginning of the end of this benign approach that courts have taken. Because the question is whether the courts really do give effect to the actual intention objectively manifested of both parties. The first part of the approach that Lord Millet proposes is fully consistent with courts' benign approach to contractual interpretation, because Lord Millet says we're looking at the agreement that the parties have entered into, the instrument, the document that evidences the agreement, and we ask ourselves whether the intentions of the parties created one sort of right or another sort of right. What sort of obligations and rights the parties created. But the second stage has nothing to do with intention, nothing to do with establishing intention. And it involves the court looking at whether, as a matter of law, what the parties have created, those rights and obligations, are consistent with one sort of right, say a fixed charge, or another sort of right, like a floating charge. So it's useful for us to look at the way in which courts have applied the various key principles that we looked at in practice, in cases. And when I say that, I've talked about the courts not looking at the economic effect, looking at substance of the obligation, and undertaking categorization of rights and obligations. Now, these are not some sort of recognized principles. It's just, I think it's useful to think about those as the key principles that keep coming up in cases. But it's, I think, most handy to look at the way in which courts have approached specific dilemmas in practice. So how the courts have categorized various agreements in practice. And the first one, perhaps familiar from land law, is relating to lease and license. Don't worry, we're not revisiting land law. If there's any panic button that I've just pressed in anybody else's, in anybody's mind, don't panic. There's no land law involved in commercial law. We all know that commercial parties nowadays don't deal with land. That's not entirely true. So you don't need to worry about land law for the purposes of this course. But it's useful to look at the case of Street and Mountford only to the extent that Lord Templeman said something interesting here. So for those of you who don't remember what the case was about, or I'm not sure whether you looked at this in any detail or not, it was a case which involved Mr. Street, a landlord, who had granted Mrs. Mountford right of occupancy of 2 rooms on the basis that her and her husband will have exclusive occupation of those 2 rooms. And Mrs. Mountford signed an agreement stating that she understood she was not a tenant. The question before the court was whether the agreement was effective to create merely a license, or whether Mrs. Mountford was in fact leasing from Mr. Street, and therefore Mr. Street would be a landlord. Greater protections are involved for tenants than for licensees. The House of Lords decided that this was a lease, not a license. But what we're interested in is the way in which House of Lords approach this question. So Lord Templeman says that there can be no tenancy unless the occupier enjoys exclusive possession, but of course an occupier can have exclusive possession not only as a tenant, but as an owner, a trespasser even, a mortgagee, an object of charity or a service occupier. To constitute a tenancy, the occupier must have granted exclusive possession for a fixed or periodic term, and there must be consideration of periodical payments of rent. In the present case, there is the agreement professed an intention by both parties to create license, so that's on the face of it, and their belief that they had in fact created a license. So they both thought that that's what they did. It is then submitted on behalf of Mr. Street, Lord Templeman says, that the court cannot in these circumstances decide that the agreement created a tenancy without interfering with the freedom of contract. But, then Lord Templeman says, that's not consistent with the rights of that parties have created. The nature of the rights that parties have created was consistent with a lease and not a license. Mrs. Mountford enjoyed freedom to negotiate with Mr. Street to obtain different terms, and they both enjoyed freedom of contract. That's true, Lord Templeman says. But the consequences, once they enter into this agreement, the consequences in law of the agreement can only be determined by consideration of the effect of the agreement. If parties think that they're creating one thing, it doesn't make it that thing just because they think it is that thing, if the effect is something else. A very colourful illustration, and I won't beat this, so I'll have to read this out to Lord Templeman. The manufacture of a 5-pronged implement for manual digging results in a fork, even if the manufacturer, unfamiliar with the English language, insists he intended to make and has made a spade. And so with the agreement. Just because the parties think that they're creating a license, creating certain rights and obligations between them, doesn't make the rights and obligations a license if their effect, the rights and obligations, the effect of the rights and obligations is to create something else, i.e. a lease. Now I have to ask, is this approach reasonably clear? Okay, good. Because I've got another quote from Lord Templeman where he emphasises the characteristics of leases that he looks at. So he looked at the exclusive occupation, the receipt of periodical payments, and a term. And once those three elements are present, the hallmarks, he uses those three as a sort of benchmark against which to measure the rights and obligations that the parties create in an agreement. And it would be very easy to approach all transactions if we had such clear criteria for each transaction. And sometimes it's very clear what transactions parties created. So, for example, in Helby and Matthews, there was a discussion whether the parties have entered into a hire purchase or a sale. So this was a case where an owner of a piano hired it to Mr. Brewster, and Mr. Brewster was going to pay certain sums of money, and at the end of the hire period had an option to purchase the piano if he wished. There was no obligation to exercise the option to purchase. He was simply hiring it for a period of time and paying installments. But unfortunately, he was a bit dishonest, and he decided to use the piano to raise finance for himself and pledge it. So he then defaulted on that loan, as a result of which the lender, who held a security right, a pledge, sought to exercise those rights in the piano. As you can guess, the true owner of the piano objected. The question was whether the true owner had a valid property right enforceable against the pledgee. Everything turned on the construction of the agreement, because if the agreement between Mr. Brewster was merely hire agreement, then the original owner of the piano was an outright owner, full legal owner of the piano, and the fact that the hirer used it to raise finance to create a pledge did not defeat the legal rights of the true owner, and all that Mr. Brewster as the hirer could do is to pledge the rights that he had, which were very minimal. So the pledgee would lose out to the true owner of the piano. But if the agreement was to be construed as creating, in fact, an agreement to sell the piano to Mr. Brewster, then we would be able to apply one of the defences to Nemodat, and the pledgee could argue that the legal owner, original owner of the piano, lost to the pledgee because the pledgee, as the third party, could raise a good defence against the true owner. So everything turned on the characterization of the transaction between the parties. And the court had no doubt that the agreement created no obligation to buy the piano, and therefore no contract to sell the piano, because a contract of sale of goods involves an obligation to sell and an obligation to buy. The essence of that contract is transfer of property. So before that property is transferred, the seller has an obligation to transfer it at some point in the future once various elements, conditions are fulfilled. But on the other hand, the buyer has an obligation to acquire that property. But in hire purchase agreement, there is no question of obligation to buy. The very nature of the agreement that the parties entered into was that there was merely an option to buy, not obligation to buy. An option to buy, which is frequently included in hiring agreements, confers a choice on the part of the hirer to acquire property in the goods if they wish. It does not confer an obligation on the hirer to purchase. Therefore, the transaction, as measured as to this hallmark of the contract of sale, was said to be a hire purchase agreement on the facts and not a contract of sale. So categorization so far looks very easy, because what we are looking at is a set of criteria that the courts have come up with, or legislation has set out for us, as to what sort of transaction we're looking at. So for example, in sale, we're looking at transfer of property. an obligation to pass property and an obligation to acquire property from the perspective of the buyer. In leases and licenses, we looked at the exclusive possession, for example. But is it always so easy? So we already looked at two cases where it was not straightforward for the courts to decide whether the documents created one transaction or the other. One was the Yorkshire Railway Wagon case, and the other one was the first case we started with, Snook. In both cases, the courts looked at the intention of the parties and concluded that there was no intention to create, in McLure, there was no intention to create security. It was a hire purchase because the purported borrower had no capability of intending to borrow on a secured basis, and the parties bona fide entered into another transaction which they were free to do under freedom of contract. And in Snook, the case was unfortunately decided for Mr. Snook that the effect of documents was that the financier was not capable of expressing intention to lend, so there was no question of a sham. There was what the documents purported to express, which was a hire purchase agreement. But distinction between, I should say by the way that distinguishing between various transactions matters in practice for various parties. So in leases and licenses, the protection for the licensee or tenant matters depending whether it's a license or lease. In the case of Helby and Matthews, it mattered whether it was hire purchase or sale from the perspective of the true owner of the piano, because of the possible defences that a third-party pledgee could raise. In determining whether there's a hire purchase or security matters because, as we said, security rights often have to be registered, and if they're not registered, they are void, whereas hire purchase agreements are not registrable. And the same applies for distinguishing transaction as sale and security. So security rights have to be registered, sale agreements do not. And it matters whether a transaction is characterized as a sale or a security. So much of this discussion you already recognize, I hope, from the lectures and tutorials that we had on security rights. Because what we're looking at is the way in which courts approach transactions and try to establish whether a transaction creates a sale or a security right. So you will have probably recognised the George Ingerfield dictum of Roma, Lord Justice. We didn't look at this case specifically, but it is cited in Welsh investments case, in Ex-Finco case. Roma Lord Justice makes it sound very easy as to how we approach transactions and how we find whether there is a sale or security. So he identifies three characteristics of sale. So first, if a transaction is such that the person of a seller is not entitled to the subject matter, and must return it to the purchaser, then that, of course, is not consistent with a sale, but it must be a security right. Also, second point, if the purported mortgagee realises the sum of money that is sufficient to pay off the loan to him and accounts to for surplus, then that is consistent with security and a loan. But if the person of the mortgagee realises the surplus from the property and keeps it for themselves, then this is consistent with sale. Because if you buy something, you just keep the profits that that thing generates. If you sell it for more on the market than you bought it for, then you simply keep the profits. But in a secured transaction, if you are a secured creditor, if you sell the thing and it generates more money than you're being owed, you must account for the surplus to the borrower. And by the same token, if in a secured transaction, the secured lender sells the asset and the amount of money that they recoup is smaller than what is owed to them, they can ask the borrower for payment that will make up the difference, because security right only secures a loan and the loan remains outstanding until it is repaid. Whereas in a sale transaction, if the thing you bought you are hoping to sell more on the market but you don't and you make a loss on your resale, then that's tough. You're the owner of the thing you bought, and if you happen to resell it for less than you hoped for, then as an owner you must suffer the loss. These would seem to be quite straightforward characteristics of sales and security rights. But as Lord Justice Dillon says in Welsh Development Agency, they are not as clear as, for example, the distinction between tenancy and license would suggest. So the reason why the distinction between sale and security isn't so easy to draw is because parties can add various rights and duties between one another and modify the very simple, straightforward effect of security or a sale. So, for example, there could be, if you sell debts, so debts, you could be owed lots of money from customers if you're a business. And you may sell those debts in order to raise finance. But of course, the purchaser of those debts does not know whether they're buying good debts, whether the customers that owe you money will pay what they owe, or whether they will turn up to be bad debtors and will not pay. So the purchaser of the debts takes a risk. And in order to address this risk, they might wish to include a clause in the contract with the seller of those debts that the seller must make up any shortfall in the event of the purchased debts not being realised in full, in case the customers that owe the debts do not pay in full to the person who just bought those debts. And if you include such a personal obligation of making up the shortfall, then that looks very similar to a security transaction, even though it's a sale. And similarly with a situation where there is a sale of debts, but you might realise more value of the debts than you hoped for, there might be a personal obligation on the part of the seller, a right on the part of the seller to be paid any amount that exceeds the price the purchaser of the debts paid for those debts, which is again very similar to a security right rather than a sale. So this leads Lord Justice Dillon to say that in relation to distinguishing sales from security rights, there is no one clear touchstone by which it can necessarily and inevitably be said that a document which is not a sham and which is expressed as an agreement for sale must necessarily, as a matter of law, amount to no more than the creation of a mortgage. So coming back to Lord Templeman's cutlery analogy, well, not really cutlery, garden implements analogy. But I like to use cutlery because it's easier for me. So if you've got a fork or a spoon, you know that the thing with the 4 prongs is a fork and the thing with a flat sort of curved bit is a spoon. But sales and security rights, it's a bit like very modern, funky cutlery. When you make a spoon with just a little bit of a fork element, does it make it a fork or is it still a spoon? This is exactly what's happening with security rights and sale. They become so closely, so similar to one another that it's very difficult for courts to say that this is a sale and this is a security. So if that's the case, then what does it make? What does it mean for our freedom of contract and for the courts respecting actual intention of the parties? I don't know. I don't have a good answer. I really hope that you will think of one. Because I think it's a real challenge. If we like certainty, and in commercial law in particular, we like to say that these are the rules that the courts follow, and they may be hard rules, but they are certain rules, and they promote certainty for commercial parties. But in terms of construing contracts and categorizing them as consistent with one transaction or the other, how do we approach situations like this, where sale and security are very similar? A designed fork is so similar to a spoon that I don't know whether to eat soup with it or not. So this is what happens in courts. So how do we approach it? Well, I think the way the courts have approached transactions is to look at rights and duties, okay, and to look at in detail at rights and duties that parties have created, and to check whether those various rights and duties are consistent with one another. And if they are consistent with one another, then they create that particular transaction that they are consistent with. So, an illustration of this approach is the Welsh, the Exfinco case itself. So I've got a diagram that illustrates the facts, and I know that we've looked at this case before, so I go fairly quickly, but I think it's useful just to be reminded of the facts. So this case involved a company, Parrot, who was selling floppy disks, and they were selling those selling floppy disks to customers for a certain price, but they also needed finance. So they arranged with Exfinco, the financier, that Parrot will sell the floppy disks to Exfinco on a sale-as-you-go basis. So sell those floppy disks which the customers have ordered from them. So Exfinco would become owner of those floppy disks, and Parrot would sell those floppy disks to customers as agent of Exfinco. So Exfinco was effectively an undisclosed principal, and Parrot was acting as an agent. The whole thing blew up before the courts because Parrot had also granted a charge over its assets in favour of Welsh Development Agency, and the question was whether the money that customers had paid for the floppy disks were property of Parrot or property of an external other financier, Exfinco, for whom Parrot was acting. If it were truly a sale agreement between Parrot and Exfinco, and Parrot was first sold the floppy disks to Exfinco, and Exfinco simply allowed Parrot to sell the disks to customers as the agent, then Exfinco would be owner of the floppy disks and also would obtain the money, the proceeds of sale from customers, on the basis of an obligation, of Parrot's obligation to account to Exfinco and hold the proceeds on trust for Exfinco when the process of sale arose. So they would not form part of the assets which Parrott could grant a charge over in favour of WDA. But if, on the other hand, the transaction between Parrott and Exfinco was not a sale of floppy disks, but only a loan from Exfinco, then Parrott would be a borrower and Exfinco would have a security right over the floppy disks, which means that Parrott would continue to be the owner of the floppy disks, and therefore any proceeds of sale would also be Parrott's and therefore available to be subject to the charge in favour of WTA. So the question was whether the agreement was a sale or a security. In the first instance, as you probably remember from, if not, I'll say again, the first instance judge said that the transaction was a secured transaction and not a sale. But Lord Justice Dillon and the Court of Appeal disagreed. They thought that the substance of the obligations was consistent with sale. But what's interesting from our perspective is that Lord Justice Dillon, when looking at the reasoning of first instance judge, of the Vice Chancellor, he said that the approach was right, because he says, as I understand the Vice Chancellor's judgment, the approach adopted is correct. The question was, for us, whether the approach was applied correctly. But the approach that they applied was to look at the rights and obligations that parties have created based on the documents, and to see whether the rights and obligations were consistent overall with the sale or overall with security. And the conclusion was, in Court of Appeal, that the transaction was consistent with a sale, not a security right. And therefore, Welsh Development Agency had to lose to Exfinco. But the case illustrates serious difficulties that courts face when characterising transactions. And Lord Stoughton, in this case, indicates that it's not made any easier by the variety of language that's been used. So when we approach these questions, we're faced with words like substance, truth, reality. Again, law is not about morality. Law is also not about finding the truth, what the parties have created. It's about finding whether the rights and duties are consistent with a particular transaction or not. And all those words that are often used by courts, like disguise, cloak, mask, label, device, sham, are all bad names, he says, and he borrows this phrase from Justice Dixon. It is necessary to discover, if one can, the ideas which these words are intended to convey. So this is very difficult, I think, for courts to approach, look at transactions and look at the words parties use, and also to look at what ideas they're meant to create, and also measure them up against what we're meant to establish in law when we look for substance. And I think it is the easiest approach is to look at the internal consistency. If a transaction creates a range of rights and duties which are consistent with a sale and inherently not inconsistent with one another, then it is a sale. The assumption there inevitably is that a set of rights and duties can only be consistent with one type of transaction. It cannot be consistent with both security and a sale. But it all depends on how we interpret the rights and duties that parties create. And again, the Ex-Finco case, Welsh Development Agency case, is a very good example of the judge in first instance interpreting the rights and duties that parties have created as consistent with security, and the Court of Appeal looking at the same rights and duties, using the same approach and reaching a different conclusion. Do you have any questions on the Ex-Finco? Is it all okay? All right, good. So, another case, which is also about determining whether there's a security right or a sale, is the Orion Finance case, which involved a lease of computers. It was specifically a lease with an option to purchase, so a hire purchase agreement, by A to B. A was Orion Finance, and B was not Atlanta. Atlantic Computers, that's it. Atlantic Computers. Atlantic Computers, B, subleased those computers to third-party customers. They were called Crown by C. And from those subleases, they obtained rents. And as the intention was that in order to secure the performance of the hire purchase agreement, of this agreement, B, Atlantic Computers, would assign all the rents to A. But as is usually the case, there wasn't just one agreement entered into between the parties, but there were multiple ones. And the one agreement that finally assigned the rents to A purported to assign the rents not by way of security to secure the performance of B's performance of hire purchase agreement, but the wording used was that B would assign the rents they obtained from C outright. So it was sale. Eventually, B and C agreed upon additional rights, termination rights, which C eventually exercised. And the question arose whether A, as the financier, could, when C terminated the agreement and no rents were forthcoming, sue B for the balance. Because if B were merely a borrower creating a security right, then B as a borrower continues to be liable for payment of the loan, for performance under the hire purchase agreement. But if it's a sale of rents, then you sell what you have, and if there's no more, there's no more. Not your problem. So A and B went to court over that. It was Crown Financial Management, so C and A. B was, the question was whether B was a grantor of security or whether they sold the rents to A. And the court looked at the various agreements and documents between the parties and held that if this were to be sale of rents, then there is no place for hire purchase agreement. You can only explain the function of the hire purchase agreement if B's commitment to A was by way of security. And it is common for the parties to enter into various agreements and promise various things. But ultimately what the courts seem to be doing is looking at the consistency of the rights with all the rights that parties have between one another. So ultimately, because of the presence of the hire purchase agreement, the performance of that agreement, you couldn't explain why B would have assigned the rents if it hadn't been to secure the performance of the hire purchase agreement. And that is only consistent with a security right, a secure transaction. So B would have assigned rents to A by way of security and not merely sold them. And there are some extensive quotes. They are all quite relatively extensive because there is very little academic writing or any other writing. So that's why there's pretty much the entire handout is full of quotes. But I think they're useful. And I think what's interesting is that the courts are quite consistent with taking a two-step approach, which is first to look at whether there's a sham. And if there is no sham, then look at the substance of the obligations. And within the substance of the obligations, to first characterize, by looking at the intention of the parties, the rights and obligations that the parties created. And secondly, to look at how they are to be categorized as a matter of law. So once the documents are accepted as genuinely representing transactions, so not a sham, then the courts approach the documents by legally categorizing the transactions and legally characterizing, construing the documents. The substance of the parties' agreement must be found in the language they have used, but the categorization of a document is determined by the legal effect which it is intended to have. And if, when properly construed, the effect of the document as a whole is inconsistent with the terminology which parties have used, and then their ill-chosen language must yield to the substance. And then the last point is that, unhappily, there is no single objective criterion which we can use to determine whether there is a sale or security. So it's a difficult task for the courts and for the parties to determine whether the transactions they've entered into create sale or security. And you might find this surprising because there's a lot at stake. A security right, if a transaction creates a security right, it could be void for lack of registration if it is, for example, created by a company and not registered in the company's house. So there's a lot at stake. But from our perspective, I think what's particularly valuable to note is, do you think it's really true that parties express objectively intentions and all that the courts are doing is merely construing that intention? Is it really true? Are courts respecting parties' intention? First of all, we've got the shams. So shams are relatively easy but also rare. But this approach that courts have taken, the two-step approach that Lord Millett spoke in Agnew, that construing intention of the parties is one thing, but then there is this other element of determining whether what the parties have created is a spoon or a fork. Is it one sort of transaction or the other? And that's quite difficult. Also, not necessarily consistent with looking at, saying that all that the courts are doing is merely looking at actual intention. Perhaps. But I'd like you to think about it. And the last set of transactions, which are very difficult to distinguish, are fixed and floating charges. So there are as you know, there were a number of cases on characterising charges as fixed or floating in relation to debts, and specifically situations where charges were taken over debts owed to a company, and the company paid proceeds of those debts into a bank account, and the bank held a charge over both debts and the proceeds of those debts collected in the account. The old approach, which was rejected by the Privy Council and House of Lords, was that parties were free to decide whether to have a fixed or floating charge over debts and a fixed and floating charge over the proceeds. But since Agnew, Brimac case and Spectrum, we know that this isn't so simple, because floating charges are charges which enable the debtor to draw and withdraw the assets from security without consent of the chargee. So when approaching the task of characterization, the courts need to look at the nature of the charges that the parties created. But the way in which they do that is different to the way in which you perhaps think about interpreting contracts. And this passage from Lord Millett in Agnew shows why, I think. So Lord Millett says that it is not inconsistent with the fixed nature of a charge on book debts for the holder or the charge to appoint to the company, its agent, to collect the debts for its account or on its behalf. It should be the chargee to appoint to the company, its agent, to collect on its behalf. But their lordship would wish to make it clear that it is not enough to provide in the debenture that the account is blocked if it is not operated as one in fact. Now, if a charge over debts is fixed, it means that the charger cannot deal with those debts, cannot sell those debts without consent of the chargee. The charge can be fixed over the proceeds of those debts when they are paid into the account. If the account is blocked, that means the charger cannot draw on that account and cannot withdraw the subject matter from the security. That is consistent with a fixed charge. But the process of interpretation and categorization that we looked at so far was a process that we undertake from the perspective of conclusion of the contract. When the parties entered into a transaction, what rights and duties did they try to create, and were those rights and duties consistent with one form of transaction or the other? But in relation to fixed and floating charges, the courts seem to be going further, because they say, well, we don't know whether a blocked account, that means whether a charge over proceeds of debts will be such that the charger will be able to draw on that account or not until we see how it is operated in practice. But this, of course, means we must look beyond the agreement. We must look at the subsequent conduct of the parties. So, one point that some Richard Cullen would probably make, although I may be putting words in his mouth, so, but at least it's a view that has been floated, is that categorization as a way of approaching determination of the substance of the agreement is very different from contractual interpretation, because when construing an agreement between the parties, courts are not looking at the subsequent conduct, whereas when categorizing the rights and duties that parties created, courts may well look at subsequent conduct of the parties. So you might look at categorization as a very different approach. But there is a possible other explanation for what Lord Millett said in Agnew. And that approach And that is to say that categorization perhaps need not be very different from contractual interpretation. Maybe they are the same. Maybe they are the same sort of exercise. But the way you explain this reference to subsequent conduct in the passage on the screen is simply by saying that in relation to fixed and floating charges, we are looking at subsequent conduct because it is an exceptional area, and therefore when interpreting parties' agreement, we are allowing ourselves to look at subsequent conduct of the parties to construe the agreement in this exceptional area of fixed and floating charges. I suspect that of the majority, there is no established view on this because there is very little writing on this. But it would seem that categorization and contractual interpretation are different exercises. They are about different things. But the question overall remains whether, in approaching documents, whether the courts are really respecting parties' intention, whether they're giving effect to what the parties have intended. And I hope I have shown to you today that, at least through Shan, courts are not. But that's okay for Shan. Shamars and Shamis should be punished for the fraudulent intention. But it's very difficult with categorization because what the parties are devising sometimes, the structure of the transaction, can be very difficult to determine. So it's I think, very interesting but also very difficult area. And it's one that I'm currently working on. So I haven't got very formulated views on this yet, but maybe if we see each other again in the review lecture, I won't promise, but maybe I'll have something more to say then. But I will come back to do the first revision lecture before the end of the second term. But for now, thank you very much for a very enjoyable first